Welcome to the Korea Now podcast. I'm your host, Jed Lea-Henry, and on today's show we have Boris Kondoch. Boris is a professor at the Far East University in South Korea and the editor of the Journal of International Peacekeeping. And importantly for the topic of this podcast, he is an expert in international law and how that relates to North Korea. Specifically, the use of force in international law, because this is what is often spoken about when we speak about North Korea. The prospects of a North Korean attack, the ramifications of North Korean threats, and what actions like nuclear tests and missile launches actually constitute inside the body of international law. But also on the other side of this, what right does the international community have to intervene in any way in the domestic affairs of North Korea? What legal basis can any country have to push back on some of these behaviors? Or, and what is often left behind in these discussions, intervene to try and correct, to offer a remedy to the human rights situation inside North Korea. Now, for me personally, this was a fascinating insight into these legal frameworks and how they can be applied or not applied to the North Korean context. For example, how binding is the injunction inside international law against aggression and threats of aggression? What threshold must these constitute? And have the actions of North Korea over the years gone over these thresholds? And if they have, is that simple violation of law enough to then justify a large-scale military response? Similarly, core articles of the UN Charter, such as Article 2, subsection 4, insist that all member states refrain from any acts of force against another state. This in some ways offering a protection for North Korea against such outside intervention. And from this there is a multitude of questions, such as does the nature of the North Korean state, how it treats its people, its pursuit of nuclear weapons, and many of its other international actions, do these in some way offer a nullification of this clause? Does this open North Korea up to acts of force inside the international community? This is a hugely complicated and interesting area of study, with so many potential and sometimes contradictory pieces of information coming to the fore. How encompassing is the right to self-defense? What evidence must be brought to bear if a nation is to ever enact this? Because of course it seems to be the case that over the years South Korea surely would have been within their rights to activate this clause. But of course there are deeper questions here. Can an accumulation of smaller attacks build up to constitute a large-scale violation and therefore the right to defend oneself? And then there are more challenging issues, such as what has become known as the Bush Doctrine, the right to preemptive self-defense. And of course, what place does cyber attacks now hold within this legal strata? And this all builds towards a much more controversial aspect of international law, but one that seems to apply to North Korea more than anything else. That is the right to humanitarian intervention. The right to intervene inside another country to try and remedy the human rights situation on the ground. In this, Boris will walk us through the history of this principle, its place in law and its place as a normative theory, along with all the challenges and controversies that come along with this, the small clauses that people try and insert to use this for their own gain, and the stuttering application of this principle over the years. And this all leads up to the responsibility to protect, or R2P, the modern embodiment of humanitarian intervention and what was meant to be at the time a new moral and legal standard for the international community. But of course a new standard that was meant to make sure that countries like North Korea could not continue along with the human rights record that they have. When this principle was dreamt up in 2001 and then adopted at the UN World Summit in 2005, it was imagined to be a split in time for the international community, a way to guarantee that massacres of the past in places like Somalia and Rwanda and Yugoslavia would never happen again. Which of course begs the question of why it seems to have failed, if indeed it has. Now, as always, this podcast is entirely funded by you, the listener, so if you do want it to continue, please consider donating at the Patreon account attached below, www.patreon.com/Jed Lea-Henry. On that, and to walk us through international law and how it relates to North Korea, this is Boris Kondoch. Boris Kondoch, welcome to the Korea Now podcast.
Thank you very much for your kind invitation.
So today we're going to be talking through international law and I suppose humanitarian law and how it relates to North Korea and how it runs vice versa. But I might get you to just to start with one of the most foundational principles of international law here. So we just build up a bit of a framework and a bit of a background for the viewers there. So what is Article 2.4 of the United Nations Charter, and how is this such an important document in international law and in the international community?
Article 2, Paragraph 4 of the UN Charter prohibits the use of force in international relations. It does not only prohibit the use of force, but also the threat of the illegal use of force in international relations, and I would call it the fundamental principle of international relations. When the norm was incorporated into the UN Charter in 1945, it was a major milestone. Imagine hundreds of years ago, states had the right to use force against each other. There were no limitations under international law. That changed with the beginning of the 20th century with the Bryan-Kellogg Pact, and then we have now the UN Charter, which tells us states are not allowed to use force except in self-defense or in case of Security Council authorization under Chapter 7 of the UN Charter.
And that is important because it seems to imply, at least in some ways, a certain amount of protection for North Korea. If people see them making threats and people see the nature of the country and ideas that they are becoming a nuclear power, but there is a very legal reading on this, of that they may be I suppose in long term protected by this clause. But a second aspect that comes through, and it comes through your writing here, is the notion of the failed state. And this is one of those things that people hear a lot in common dialogue: failed state, but it doesn't often mean much. But it may have implications for this particular article, because I suppose in some ways, if a state is failed, if it doesn't qualify as a state, then it may not deserve the protections defined there. So I might get you to walk us through this issue of failed state and how it does or does not impact that article.
Yeah, I think for the better understanding for the fans of your podcast, there is no definition of the word failed state. What does it actually mean, failed state? Does it mean a state without a functioning government? Is it a state without an effective government? And scholars have always tried to find new arguments for also using force. And here, in case of North Korea, it's pretty obvious. For many, it's a rogue state. But is it really a failed state? I would still think it has a functioning government. We know all from media, the head of the government, Kim Jong-un. And I think it would be an oversimplification calling North Korea a failed state.
What about a rogue state then? You brought in the terminology there. I imagine that rogue state as well is one of those terms that doesn't have a clear definition.
Yeah, that's also the same problem. I think a rogue state is probably a state which possesses weapons of mass destruction, and it's a threat to its neighbors and the world. And some people have said we should loosen the restrictions on the use of force. But once again, I think it's a core principle of international law. Only under very few limited circumstances, states are allowed to use force. We had a similar debate a couple of years ago when the US attacked Iraq. At that time, the discussion was about also the interpretation of Security Council resolutions. But the issue of should we change the rules under international law when it comes to rogue states? But I think it has not become widely accepted by states and scholars. And the question is also, who is in the position to make a decision whether another state is a rogue state? From the perspective of North Korea, probably the United States is a rogue state as well. It's not my opinion, but I think it could be the opinion, of course, of the North Korean government.
Yes. And on that idea, this I suppose those two definitions are problematic, as you said. But if we return back to the article itself, to Article 2.4, this protection against, international threats and international aggression, One of the key pieces of language there is international threats. And this is important for how it may relate to North Korea, because people listening, even if they don't know much about North Korea, they seem to be a nation that seems to make a lot of international threats. Sure, they don't make a lot of international aggression, sometimes towards South Korea in the past and things like the sinking of the Cheonan, but they certainly seem to make international threats. So would this place them in violation of that first clause, at least in your estimation?
Well, is North Korea violating it as a threat? I think the Security Council has the option to deal with threats under international law. Sometimes states make claims that they have a right to preemptive self-defense. So to act in self-defense against threats caused by other states. But this is also, according to my personal judgment, not widely accepted by states and scholars. So if a state is a threat to international peace and security, this situation should be handled by the Security Council, and then the Security Council can make an authorization. It will adopt probably a resolution saying that states could all use all necessary means to stop a threat against peace. In this case, the threat caused by North Korea because of its nuclear arms program. But the problem, and that's the big but here, there will be no Security Council resolution under the current circumstances. China and Russia will veto, and then no Security Council resolution can be adopted under Chapter 7 of the UN Charter.
I suppose that's a very important point. So later on in this podcast, we're going to get towards humanitarian intervention and R2P. And even then, when we get there, one of the things that is going to keep coming up is the problematic or the important role played by the UN Security Council. So I might get you just to introduce that now so people know just how important and how central this is. Despite all the legal principles that we're going to be speaking through today, none of these actually authorize the use of international force, international aggression, unless it is distinctively and explicitly defined first by the Security Council. So despite international law, it must first, at least in my understanding, first be authorized by this body. So the law doesn't necessarily mean you actually have the right to do anything about the infraction of the international law unless the Security Council allows you or authorizes you to do so. Is that correct?
Yes, that's also my understanding of it, and maybe also for the listeners of your podcast. The Security Council is composed of 15 states. 10 are non-permanent members, and 5 of them are permanent members, the winners of World War II. And they have the so-called veto right. So if they don't like a proposal on the table, they can always block a decision and say, we are not going to pass a resolution because we're against this kind of way of handling the situation. And in case of North Korea, I think there's always a high likelihood that China or Russia would veto the use of force against North Korea. And last but not least, let me mention the Security Council is a political organ. That means it has a wide margin of discretion when and how to act. There is no obligation under the UN Charter for the Security Council to act. Probably there's a moral pressure on the Security Council to act in certain situations. But again, what I said before, the Security Council is an organ which has a margin of discretion when and how to act.
So let's move on then. So from that idea, let's move on to self-defense. Now, this is one of those things that I suppose many people listening it would make very common sense of. The idea that if you are a nation in the international system and you are attacked, you have a right to respond. And this is one of those principles you understand in basic society, and also so it corresponds quite neatly. And this is designated under Article 51 of the UN Charter. Again, a very central clause here. And this may have a lot of people, as I mentioned earlier, thinking about South Korea. So there's not many nations that could claim self-defense, at least not in a very real sense, not as a preemptive self-defense, but a actual self-defense against North Korea. But South Korea have been attacked by North Korea, not just in 1950, but over the years. And if you, as I mentioned earlier, if you go back even to 2010, there was attacks on the sinking of the Cheonan and the attack on Yongpyeong Island. So do you see South Korea as having a viable claim to the right to self-defense against North Korea?
Not at the moment. If you look at the wording of Article 51 of the UN Charter, it says a state has a right to self-defense if an armed attack occurs. And the problem with their wording is, what does actually armed attack mean? So the use of force should reach a certain threshold. So not every time maybe someone gets shot at the border between North and South Korea, South Korea has automatically a right to self-defense. So the use of force has to reach a certain threshold. There must be a certain number of people killed, injured, etc. So, but small incidents do not trigger the right to self-defense.
And I suppose in that same calculation is the problem of evidence. And it is my reading here that the problem of evidence has to be supplied by the attacked or the aggrieved party. And of course, that is a very challenging thing to prove. It's easy to prove you've been attacked, but very hard to prove who attacked you, I suppose.
Yeah, I think the problem is you have especially this problem in cyberspace. Let's assume one country is attacking another country in cyberspace. The victim of the attack has to prove which country has been behind the attack. There has been a couple of cyber attacks committed against South Korea in the past. Attacks against Incheon Airport, the subway system, one of the big banks, the Noyoung Bank. But no one died at that time, and a lot of people pointed to North Korea and said, North Korea is behind that. But was there conclusive evidence? I'm not sure about that. So, and it would probably be, as I said, also these attacks also do not trigger the right to self-defense. The cyberspace attacks must have the same effect like an ordinary kinetic attack, and no one died in these cyber attacks.
So let's pause on that for a second, because that is a very interesting idea. Does that say in principle that a cyber attack doesn't violate Article 2.4, the one that we first mentioned about the right, I suppose the block on all international aggression? So in a way, would South Korea not have a right to claim that they have been attacked under that article?
Yeah, I think it's highly problematic because no one died. But let's assume the following scenario. Someone is attacking Incheon Airport and airplanes are colliding. People get killed. Then probably the question will come up, should we militarily respond to the cyber attack? But as long as probably maybe only property gets destroyed or malfunctioning of computers, or someone is stealing information, to my understanding, that does not trigger the right to self-defense under the UN Charter.
That is a very interesting thought, because I suppose in many ways people see cyber as a future of, I suppose, not just North Korean action, but of warfare in general. But I just suppose, does that in some way show the limitations of international law in your understanding, or just the outdated mode of international law? Or do you think that limitation on lives lost is actually a good one?
I think we don't need new rules. I mean, one possibility is also, of course, I asked my students, so what should we do in case of cyber attacks from North Korea? And then one of my students said once, we should get better software. Yeah, so I think this is... It could be one way is of course the software, and of course a state also has a right to respond back in cyberspace. So you could also hack back. That would be my suggestions. I think the rules in international law are good, but of course we have to adapt them to new technologies and new challenges. But the rules themselves are good. And the problem, as I said before, is really how can you provide evidence? Someone could start, I live in Daejeon, and let's assume I'm a North Korean spy. I could conduct cyber attacks here and somewhere from my home. And how can you prove that the North Korean government is behind it? So cyberspace is very tricky. And I think in order to stop it, it requires the cooperation of states. Yeah. And I must admit also, I'm not familiar with the technical knowledge about cyber attacks, but I think I'm pretty sure it's quite complicated to prove that a particular state has been behind an attack. And I think it's as you said, one of the future scenarios. Let's assume a conflict breaks out between two states. States will use ordinary, just traditional military force, but at the same time, probably they will attack each other on cyberspace, because that can also cause a lot of damages.
So there is another principle there, that let's bring forward something else, that just putting ourselves in the seat of the South Koreans, and I suppose not South Koreans now, but maybe a few years ago. And this is something that I suppose came to my mind when you mentioned the armed threshold principle before, that it's not enough simply for there to be an attack. It has to be a certain scale of attack to justify international conflict. And that is the pinprick theory of international accumulation, the idea that, one attack only kills a few people, but over the years, of course, North Korea have peppered the South Korean government. So it may not be obvious in the last 5 years or so, but if you go back, there have been assassination attempts and all sorts of spy attacks and sink-ins and attacks and shooting downs of aircraft. So how does this sit in international law? Is there a place for the idea of this accumulative pinprick theory in international law?
My response would be, I think it's understandable that states are discussing the pinprick theory, but Article 2, Paragraph 4 of the UN Charter should be interpreted in a restrictive manner. And the use of force, I think it would lead to more violence if we accept the so-called pinprick theory. And in the past, the South Korean government has been always very smart, not immediately reacting to smaller incidents like border shootings. And even also in case of the Chonan, there has been not a counterattack against North Korea, because I think the government must have felt it would have led to the escalation of violence. Yeah, one incident could trigger a bigger conflict.
And I suppose from your answer there that you may have a similar sort of view on the idea of preemptive self-defense, or I suppose for many people listening, the Bush doctrine. This is his justification, as you mentioned earlier, for his attack on Iraq. The claim that we don't have to wait until a nation actually has a nuclear weapon flying towards us. If they're building one, for example, and we have a credible belief that they're going to use it on us, then we have every right to go and attack them. So how do you view this? Do you see it in the same kind of way, as it is just going to lead to preemptive violence and escalating of conflict? Or do you think there is a place for this in international law?
There is I think no place for that in international law. But of course, some international lawyers have made the suggestion. So I think it has been formulated also by lawyers of the Bush government at that time. And I also have some understanding for it. I mean, it's of course, it's not easy to handle this situation. Democratic states don't want to have rogue states possessing nuclear weapons or weapons of mass destruction. And the problem with nuclear weapons is always, as soon as a rogue state or a state like North Korea possesses nuclear weapons, and if they possess them, it's already too late. So you should maybe destroy the nuclear facilities first. But again, I think it leads to the escalation of violence. And what I said also previously before is that the North Koreans could make the same arguments towards other states. For them, the United States are the enemy. They are surrounded, except China, by enemies. So they could also come up with the same argument and preemptively attack maybe facilities in South Korea or in the United States.
And so before we move on to humanitarian intervention, which of course a lot of what we mentioned will really drill into, it's going to come out a lot more. There are a couple of principles that I've seen you mention through a lot of your writing here. And from my understanding, they're very central principles in the understanding of just war theory, but I don't think they're mentioned in the UN Charter, and that is the ideas of proportionality, necessity, and immediacy, the kind of things that designate, so for example, if there was to be an attack on South Korea or Japan or America, even if that was there, and even if the Security Council justified a response, the response would have to take on certain parameters. It doesn't mean that you could simply go carte blanche and attack as you will and destroy whatever you like.
Exactly.
So please introduce these ideas for us before we move on to humanitarian intervention, because that is one of the things that is going to keep coming up when we do go there.
Yeah, so also self-defense has to comply with the principle of proportionality. Maybe let's take a day-to-day example. You're trying to hit me, with your hand. That also would probably give me the right to defend myself, but not shooting you. So the total destruction of North Korea, for example, would probably never be proportional under international law, except there is a very, very serious attack from North Korea. So if there's an attack from North Korea, the counterattack has to be on a similar scale like the North Korean attack.
And so from that broad idea here, there is one other element that I just want to briefly introduce here before we get on to humanitarian intervention, which of course is in many ways the way that people tend to see North Korea. But this involves, this next question, I suppose, involves the bit that you mentioned earlier, the idea, in its view, is surrounded by enemies. And that is the idea of collective self-defense. And this is something that is in some ways enshrined in customary law, if it's not explicitly mentioned in international relations. That is, for example, if South Korea were to be attacked by North Korea, this principle, in my understanding, would allow other nations to assist South Korea. By definition, it wouldn't be a violation or an act of aggression if they came to help an ally or any member state that simply asked for help.
Yeah, that's correct. So I think there's the principle of collective self-defense. Yeah. So the United States or Japan could help South Korea in case of a North Korean attack. So I think it's also enshrined in the UN Charter under Article 51, because it does not only speak about the individual right to self-defense, but also to the right to collective self-defense.
Now, with that, I suppose that broad legal framework already in the bank here, let's move on to humanitarian intervention. So before we get into the weeds of it and all the complex details and as we move forward to R2P, I might get you to take us back to the history and the broad idea. It's one of those terms, again, that people hear, humanitarian intervention, but they may not have a clear understanding of just what it is. It gets confused with international aid and humanitarianism and things like this. So I might get you just to give us a little look back in history here and just a brief overview of what humanitarian intervention is as a principle.
Humanitarian intervention, as I understand it, it is the use of force by one state against another state in order to stop gross violations of human rights. This has been debated by international lawyers for a very long time. For example, you find that in the writings of the father of modern international law, the Dutch jurist Hugo Grotius, who lived in the 17th century. He also wrote about humanitarian intervention. And my understanding of that doctrine is that it's a very controversial issue.
Sorry, please.
So I think you have different opinions about it. Some people said it's if you have the consent from one state to intervene. For example, let's say there would be a flow of refugees or flow of people going to China, and then China would ask for the consent from North Korea to stop the flow of people. Then this could be probably legal. And then some people are saying there's something like an emerging norm. There's something, it has not crystallized into a norm and states cannot claim it now, but it looks like something is emerging. But I tend to stay with scholars, have the same opinion like scholars like Cassese and Zimmer, who said there is no legal regime allowing humanitarian intervention under international law. And it's also open to abuse. How do you know that one state is just intervening in the affairs of another state just for humanitarian purposes? And my understanding, and also it has never been claimed by states here in Northeast Asia, despite the problematic human rights situation in the DPRK.
So I suppose I understand what you mentioned there, and this is one of the things that will come up a lot, is this idea that humanitarian intervention throughout the years has often been poorly interpreted from either side. That the side often going in can see it to be enacted for very reasonable moral principles, as in violations of these great charters such as the Genocide Convention, for example. But the side on the other side, the side being intervened upon, I suppose, see it as a new form of imperialism. They would say something along the lines of, what nation in the world doesn't violate human rights in some capacity? And you are picking on us, and you are using a deliberate tactic of international law to violate, to, I suppose, intervene, and it's all done under this guise of humanitarianism. And that, I suppose, is one of those great dichotomy of humanitarian intervention, I suppose.
Yes, that's correct. But also, maybe also for the listeners of your podcast, there have been relatively few occasions when states intervened in other states, and you could claim a right to humanitarian intervention. During the 1970s, India intervened in Bangladesh, Vietnam, and Cambodia. But in both cases, I think the intervening states claimed the right to self-defense, not the right to humanitarian intervention. And then during the 1990s, we had NATO's intervention because of the gross violations in Kosovo, and NATO attacked Yugoslavia at that time. That was very controversial, and it shows you the reluctance of most states accepting a right to humanitarian intervention. And China at that time was very critical of NATO's airstrikes.
So let's touch on China for a second, at least the Chinese perspective, because it seems as though why it is so controversial, this principle, and why countries like China often push back against it and see it as imperialism, is a mention inside the Charter itself, that is Article 2.7, and this says that nothing contained within the Charter shall authorize the United Nations to intervene in matters which are essentially the domestic jurisdiction of any state. And countries like China, and in this case North Korea, might simply say our poor treatment of human rights is a domestic concern, not an international concern, and therefore not valid as a form of international aggression or international intervention.
Yes, this argument has been used for also quite some time, but my understanding is that states cannot hide or shield behind Article 2, Paragraph 7 of the UN Charter when we discuss crimes against humanity, genocide. It's not a valid defense. If one state commits genocide against its own population, it cannot argue this belongs internally only to the internal affairs of that state.
And another principle there, and this is from China. In some ways, this is in many ways, this claim is going to come from China, but South Korea could have a theoretical claim to this too. And this is something you mentioned in your writings, though you do say there is no agreement on this. This is one of those murky aspects of international law, and that is the idea of rescuing nationals abroad. So for many people would understand, there are a lot of Chinese people in the border regions doing trade in North Korea at the moment. But though it's not open at the moment, there used to be the Kaesong industrial plant where it was open, and there is a lot of talk of reopening it. So, for example, if North Korea were to shut its borders tomorrow and keep a significant amount of Chinese or South Koreans inside the country, what right would these two nations or any other nation in that situation have to go in and extract those citizens?
Whether there's a right to rescue your own nationals abroad, it's one of these controversial issues under international law. Let's assume North Korea would give its consent to rescue Chinese nationals from their territory. This is unproblematic. The whole issue becomes problematic if China moves in with the military rescuing their own citizens. Probably there would be not strong condemnation from neighboring states. There would be some sort of understanding because of the pariah status of North Korea. But under international law, I would find it highly problematic.
What about the idea of intervention by invitation? And that seems to be less so problematic. So if, for example, North Korea found itself in this run through a hypothetical here, if they found themselves in a humanitarian situation, and maybe they found themselves in a situation where the international community actually seemed to be willing to do something about this, maybe intervene, they would be within their rights, for example, to let South Korea or China intervene themselves and in this way stave off a broader international intervention in the South, in as far as they would say, yes, we have this crisis on our border and we are choosing who we want to come in and clean it up. And I've seen you make mention a few times that a similar kind of claim has happened in the past with Czechoslovakia in 1968 and Hungary in 1956 in regards to the Soviet Union.
Yeah, so I think we had these cases in the past. It's more than half a century ago that but at that time the Soviet Union intervened in Czechoslovakia and Hungary, so in 1968 and 1956. Western states at that time rejected the claim of a right to invitation. Nowadays, I would think that most people and most scholars and states would be supportive of that claim if the military action is undertaken upon the request of the lawful government of another country. Yeah. So in principle, any state or from North Korean neighbors could intervene upon the request of the North Korean government.
And there is, I suppose, one more point. So before we move on to R2P, there is one other thing that comes up. And this is, I suppose, one of those aspects that doesn't seem to have much basis in international law, but it does come up a few times. And it's certainly one of those things that gets invoked by larger nations such as China over the years. And this is the idea that intervention based on historical claims. And this is the idea that, I suppose, when it comes into the situation of North Korea, it may be the situation where China could justify invading North Korea based on a very old historical claim where China, in some ways, was ruling over the Goguryeo period, the Goguryeo kingdom during the Three Kingdoms period. And this is a very old historical claim, but what right would a country have to invade another simply based on historical claim to the underlying land? Because this is one of those things that does come up a lot. People, as we see around the world, this idea that a historical claim to land, it's one of the issues holding Palestine and Israel back. It's one of the issues why Turkey and Greece are fighting over Cyprus. It's one of the reasons why China and Japan are fighting over islands. So what right would a country have to do this?
There is no such right under international law. Just imagine I'm German and my government would claim the Alsatian region back and invade France. That doesn't exist under international law. And I should also say, in favor of China, China has never claimed that it could also intervene in North Korea based on these historical claims. Yeah, there seems to be a link between China and the Shilla and Paekje kingdom, but in fact they never said we are planning to incorporate the previous Chinese territories back to the mainland.
And as a final point here, let's talk about, before we get to R2P, I know I said we would then, but let's talk about sanctions there. This is one of those things that does come up a lot, simply because it seems like a secondary measure. As in, over the years, the Security Council, which we mentioned, is the final arbiter on whether a nation can attack another or use military force against another. The Security Council over the years seems to have fallen back on sanctions, especially when it comes to North Korea. So, for example, they have passed a certain amount of resolutions that in some ways have called North Korea and North Korean actions, such as nuclear tests and missile launches, as threats to international peace. But instead of going ahead with an actual military authorization, they have fallen back on sanctions. So how do you see this role? Once again, I imagine North Koreans might see sanctions themselves as just another form of warfare.
Well, yeah, of course, from the North Korean perspective, someone could see it as warfare, but it does not trigger any right to self-defense, for example. But the sanction, I think you mentioned an interesting topic. I'm also working on it at the moment. The sanction regime imposed on North Korea raises also a couple of questions under international law. Are these sanctions effective? Are they proportional? Are the UN sanctions targeting the right person? North Korea has also claimed that I think some of the sanctions are even genocidal and stuff like that. I personally disagree. I think the sanctions regime is problematic because for some reason North Korea still has a nuclear weapons programs. They managed to get nuclear material. What countries have actually violated the sanctions regime who helped North Korea? And to what extent do these sanctions really have an impact on North Korea? This is one of the reasons why North Korea is talking to the United States at the moment. And in defense of the UN and the UN Security Council, I should say all these sanctions regimes in the recent past, they include humanitarian exemptions. So states can still sell medicine and medical stuff to North Korea.
So let's talk about that humanitarian exemption, actually. And just as a principle here, that's a little bit too fascinating for me to push through, because there is humanitarian exemptions for these sanctions. And that becomes one of the big controversial concerns for many people. So, for example, you try to target sanctions as well as you can. You want to target the upper regime. You want to target certain countries that are trading with them. But you don't want to, as much as possible, impact the daily lives of people on the streets or in the farms, because in many cases they are on the daily bread line. They are really in desperate need of food in some cases, but really any interruption to their lives could be fatal. And this becomes one of those problems because there is a feeling out there, and I've seen some commentators bring this up, that if you simply give a country like North Korea food aid, for example, then this is a modern, strong, this not strong in a sense, but they have the capacity to feed their own citizens. But if foreign countries decide to feed their citizens for them, they simply will divert more and more funds towards military operations or to luxuries for the elite. And this removes certain pressure. So what do you see about this exemption? Is it something that is vital, or is it something that is potentially damaging to the regime and strengthening of the North Korean regime?
Well, there are, of course, pros and cons arguments, but I think sanctions should not amount to collective punishment. They should only be a response to a threat to international peace? Some people might say food aid helps the regime to stay in power. Of course, yeah. But the sanction regime has not been imposed on North Korea that to change the government there, but to give up its nuclear weapons program. So I think having these humanitarian exemptions is a wise and humanitarian response to the current crisis on the Korean Peninsula.
So let's push on here to the responsibility to protect, or I suppose, as we're going to refer to it in most cases, R2P. So R2P is a very modern phenomenon. It came about in the 2000s, but I suppose its history dates back a little bit to the 1990s and some of the unexpected kind of challenges that emerged. At the end of the Cold War, people had this optimistic feeling about the world. Like the Cold War was over and we can look forward to this new era of prosperity without this looming shadow. And then these crises in places like Yugoslavia and Rwanda and Kosovo, they all kind of emerged and they shocked the international community in many ways, these great big humanitarian civil wars and genocides and conflicts. And then there became a concern that the world was watching these things happening and not intervening because there was this strong norm backed up by legal principles of the protection, the idea of non-intervention in the domestic affairs of other countries. So I might get you to take us there and to let us know what R2P was and how it was a response to some of these challenges and these concerns.
Let me start from the beginning. I think for maybe someone who is not familiar with international relations theory and international law, it's probably a relatively new term, R2P, the responsibility to protect. It's a normative concept. As you said, it developed in response to the mass atrocities committed during the 1990s in places like Rwanda and Srebrenica. And that time, the international community has done too little, too late. And then the issue also came up, should we militarily respond to these kind of mass atrocities, or what kind of mechanisms should we develop? And then there was a Canadian commission, the International Commission on Intervention in State Sovereignty, and they first articulated the so-called responsibility to protect, or abbreviated R2P. What does the R2P say? Every state has an obligation to protect its own citizens from genocide, crimes against humanity, war crimes, and ethnic cleansing. And if a state does not live up to this obligation, it becomes the international community's responsibility to protect these citizens. And this sounds good on paper, but translating the R2P from words to deeds is the issue. And that's probably what we are discussing now in the next couple of minutes. How does that apply to North Korea? What can we do to protect the citizens inside North Korea? And is it actually a good decision to discuss these human rights issues at the moment where North Korea it looks like they are establishing peaceful relationships with the United States and South Korea?
Yes, and from that first claim there, before we get into the actual nitty-gritty of North Korea, this is a widely acceptable principle, isn't it? So from that first Canadian Commission, that was 2001, it was then accepted in 2005 by the World Summit, and it's been reaffirmed a number of times. So countries like North Korea, just to give us a framework here, countries like North Korea, the ones that we would look at in this version, North Korea, South Korea, China, are they all signatories to this particular convention? And how central is it? Is it a accepted principle of international law, or is it just a normative understanding these days?
Well, that's a good question, Weber. To what extent the R2P has a certain status under international law? Of course, states have an obligation not to commit genocide and crimes against humanity. There's, for example, the genocide conventions. And there are also certain duties following, I think, for states that their neighboring states are not committing these kind of crimes. But the status under international law is a little bit vague, I would say. Is Germany under an obligation to prevent crimes against humanity in North Korea? Are we not expecting too much? There are many places around the world, I think, where governments are committing terrible crimes against their own people. Imposing a heavy duty, I would probably call it a normative concept, which can be used as a guideline and guidance. It reminds us that states should do something, even if it's in their not their neighboring states committing these terrible atrocities. There's also no international convention, for example, on the R2P. We have it as a concept. States are aware of it. Sometimes states are referring to it, but in some cases, nothing is really happening or not enough is happening, and no one knows how to stop mass atrocities. And I think it's a key example for how difficult it is to implement the R2P is North Korea.
So let's move on to North Korea then and have a look at this, because many people, if they are familiar with R2P, would have heard its name being bandied around a lot during, I suppose, 2011 when the invasion of Libya happened. It's one of those principles that really was ringing in everyone's ear at that time. And as you mentioned before, R2P moves beyond it did in principle, and then maybe it was watered down when it became a legal document. But it tries to move beyond the idea that we should help countries. And it tries to change it to an idea that we must help a country. So if a country is failing or unwilling to protect its own citizens, not just that it'd be nice if we helped, but we have to help. Our legal obligation is that we must go and help them. And this is not just militarily, of course, we have to give aid and state building and things like this. But this, of course, brings us to North Korea, who in many ways, at least from my reading, has managed in some ways to be forgotten from R2P. Not forgotten in all senses, but it hasn't often been central to the discussion of R2P. But it seems to be one of the world's greatest human rights violators. So maybe take us in to have a quick look at the human rights landscape in North Korea and how they may or may not be in violation of international law that would make them subject to R2P interventions.
What should you know about the human rights situation in North Korea if you have never heard about it? North Korea is among the worst human rights violators in the world. It's one of the least free societies in the world. As you said, for a very long time, there has been not much focus on the human rights situation. That changed dramatically in 2014 when a UN commission published a report stating that North Korea is committing crimes against humanity, in particular against inmates of political prison, ordinary prisons. They're also committing these crimes against religious believers, people who have fled North Korea and had been sent back from China. And ever since then, I think the issue is on the table, but it comes up only from time to time. At the moment, the focus in the media is most of the time on denuclearization. And the Trump administration also is not heavily focusing on it, but they are discussing how to disarm North Korea. And Moon Jae-in, also my personal understanding is he wants to help the North Koreans simply by providing food and establishing better relationship before he really comes up with the hot issue of human rights.
So let's talk that through then. That's an interesting understanding here because, as you mentioned, that commission of inquiry really outlined just how North Korea had violated its international law in this regard. So R2P focuses on 4 crimes: genocide, crimes against humanity, war crimes, and ethnic cleansing. And that commission came out very strongly against the crimes against humanity and laid out a whole series of ways in which North Korea had violated this understanding here. But despite showing that North Korea has not been protecting its own citizens, you've said that the international community has deliberately stayed away from this. And this is not just people at a distance, but South Korea as well here. So what do you make of that approach, this idea that it may not be the best idea to pressure a country like North Korea into changing its particular ways? Now, it seems a bit like a Chinese kind of position over the years, as in we can talk about anything, but if you want to start talking about human rights, then we're going to get nowhere. So do you see that there's any value in pushing North Korea on its human rights situation? Or is it one of those hard questions of, is it just going to cause more problems? So do we have to make, as you mentioned, Moon Jae-in, the idea of that, let's make some small preliminary steps first and worry about human rights later on?
Yeah. Also, I mean, maybe let me add one sentence. We don't know what has been discussed behind closed doors. So I think when President Moon met Kim Jong-un or Trump met Kim Jong-un, we don't know what they discussed behind closed doors. Nothing, I think not so many details has been released to the press. It looked like a big media event, but who knows, maybe President Moon said to Kim Jong-un, please improve the human rights situation in your country. And maybe Trump did the same thing. But to the outside world, at the moment, the focus seems to be on denuclearization. Some people may think, this is a smart move. We can focus on human rights later. Others are very critical. They come usually from the human rights community, from NGOs, people who are working with North Korean escapees, and they are very critical of it. They said we should not neglect that topic. The situation in North Korea, the human rights situation, has not really improved much since 2014, when the UN Commission published that big report. And some people point out and they say, well, and these two issues are connected, human rights and nuclearization. Without the suppression of its own people, Kim Jong-un could not have built these nuclear arsenal. So I think it's a very tricky question. I personally would combine them in talks, but I understand also the current position of the Trump administration and Moon Jae-in's administration. There are no easy answers to these very difficult problems.
And you mentioned Kim Jong-un there, and this brings in a very important element in all of this, the idea of the responsibility heading up to the upper leadership here. Now, we notice a lot around the world of often African leaders who are being arrested or can't leave their countries because the International Criminal Court, for example, has warrants out against them. And these warrants tend to apply to those 4 crimes that I mentioned earlier. And people out there might be thinking to themselves, how is it the case that high-level members of the North Korean regime are traveling to countries like South Korea? They're going to go to Vietnam in a few weeks' time for the next summit. And some of the people that are making these trips, sure, it's not Kim Jong-un himself. He won't be going there. But people like Kim Yong-chol and people like this are the people who are blamed for example, the sinking of the Cheonan. So are there any International Criminal Court warrants out for North Korea? And if not, why not?
To my best understanding, there is no warrant out at the moment. One possibility would be to go through the Security Council. The Security Council is referring the case to the ICC, but China would definitely veto such an attempt. And just also imagine, would you talk to someone about denuclearization if you have an arrest warrant on the table, if someone wants to put you into prison? So I think it's not a smart move at the moment to discuss these criminal liability issues with North Korea, and also not to make them public.
And R2P is broader than just a military intervention. It's also a lot of state building involved in that too. So it involves the responsibility to react, the responsibility to prevent, the responsibility to rebuild, things like this. So Is there any way of seeing countries like South Korea, for example, who are trying to invest in Kaesong and build railroads, and they're having a new détente in many ways. They're trying to have a sunshine policy Mark II. Would there be any case for them to claim that they are fulfilling their R2P responsibilities, as in, sure, they're not militarily involved in themselves, but they are trying to build up North Korean state capacity so that they can protect their own citizens?
Yeah, well, I think you could still say that they could maybe push harder for the human rights issues at the moment. The idea is also, when you discuss R2P, is what are the best and reasonable means to end atrocities in another country. One way I think here would be to put more diplomatic pressure on North Korea. Another option would be to say you impose sanctions. And individual states like the US have also imposed sanctions because of human rights violations. Is it a smart move? Would it change the situation? Not really. I think it would make the situation at the moment very tense. But on a diplomatic level, I think people should discuss human rights issues. And one argument could be also maybe to leave the human rights issues also to other actors than states. Yeah, the United Nations, for example, has an office in Seoul collecting evidence about crimes committed by North Korea. So you could have other actors pointing to North Korea and saying, stop human rights violations. It does not have to end up simply with state actors. Yeah? So NGOs and also institutions like the United Nations, I think, have a job to do to implement the R2P in regard to North Korea.
That is an interesting question there, because as you mentioned, there are these offices and this large one in Seoul that is collecting human rights violation information. How important do you see that is? Or there is a way to view that, I suppose, of saying it is almost as harmful, if we buy into the principle, of course, it is almost as harmful as an International Criminal Court charge, in as far as, sure, there's no arrest warrant out there for the upper leadership, but they are aware that all the crimes they are committing are being collated, and in any future case when the regime changes and becomes a normal country, or reunification, or whatever the process is, these crimes will then come to the fore, and then convictions will follow after that. So do you see that as a challenge for peace in North Korea as well, in the same way that an International Criminal Court Commission might be?
Yeah, that's a huge question. It's normally left out from debates, especially I think when you go to conferences here in Korea. South Koreans are very much interested in reunification. And let's assume the day unification becomes an option, the issue of human rights violations come back on the table. And that makes all kind of cooperation with North Korea and a peaceful transition very difficult.
Because the elite in that situation would be the ones, I'm assuming the elite, so Kim Jong-un and his inner circle would be the ones that are negotiating the peaceful transition, and they would, I suppose, be recognizing that if they achieve a peaceful transition, a peace will be achieved for everyone except for them, who will end up in prison, I suppose.
Yes, that's right. So I think it's a very, very complicated situation. And just think back in the last 60, 70 years, how many times did someone put the previous leadership on trial? Could there be something like the Nuremberg trials for North Korea? I think I should probably not even mention it here, yeah, because the government in South Korea is trying to establish peaceful relationship, and you cannot come up with these kind of ideas of individual criminal responsibility at the moment.
And what space would you imagine there might be in this situation? So I suppose one way out of this, one avenue away from this, is countries that have things that have happened in places like Chile and Rwanda, where they've agreed not to prosecute people as long as they take part in these peace and reconciliation commissions. The idea that you admit your crimes, you talk about your crimes in public, but you don't, and if you do, then those crimes go on record. The victims are in many ways quite happy because they have recognition of the crime that's been committed against them or their family. But there is no conviction, and therefore there's an idea that a nation can then move forward peacefully and leave its past behind it anyway. Do you see this as having any viable way, or are there structural limitations in terms of this?
That's another very complex question you're raising, and I don't want to give you a wishy-washy answer, but it is also something I'm working at the moment on, and I think it's the issue is there a kind of duty to prosecute certain crimes under international law, and my understanding, yes, there is. But on the other hand, many countries have actually adopted amnesties after a conflict, and people didn't go to prison. There seems to be the counter argument saying there is no such duty. In case of North Korea, for example, the UN Commission of Inquiry, I think, has ruled out the possibility of a truth commission like for Chile or South Africa. So they think that the commissioners for the crimes are so grave, you cannot simply just people go free and establish some kind of a truth and reconciliation commission. But I think this is also a little bit left for the future, but it's one of the very delicate questions.
And as we begin to come to an end here, I might ask you some, I suppose, some challenging questions about the future of R2P and North Korea as well here. So one of the things that many people listening R2P came in and it imposed this new normative standard on mass atrocity crimes. But many people listening might think, but North Korea have already, in some cases, signed up to a number of situations where they have already in violation of international norms. Just for example, they have signed up to the International Covenant on Civil and Political Rights, the Convention on Economic and Social Rights, the Convention on the Elimination of All Discrimination Against Women, the Convention on the Rights of the Child, and it does go on. So do you see in this way R2P offering anything new? So just for example, a country like North Korea that signs up to international treaties in the past, violates them, has nothing done against them. Is R2P an important movement in this regard? Is it something new? Is it important? Because this is one of those places where international legal scholars like yourself have a lot of debate, a lot of argument about whether R2P has actually added something to the world.
Also, I think there's no easy answer to that question. Some people might say North Korea simply shows the limitations of the R2P because there are not really feasible options on the table. On the other hand, I think the R2P, as I see it, is a constant reminder that states have to do something about when mass atrocities are committed around the world. And the human rights dialogue with North Korea should be seen as a long process. And probably realizing and implementing the R2P will simply take more time. It's nothing we can fix within a very short period of time. And the head of the UN Commission, Justice Kirby, said the commitment of the international community should be that of a marathon man, not that of a sprinter. And I think that's probably a good conclusion.
And that might be a good conclusion to lead us on. Just as a last question, though, how do you see, this is a very hard question, a very hypothetical question too, how do you see this future continuing? So we've gone through a lot of challenges today, a lot of legal principles, and just how fraught or how successful they may be. So how do you see the future negotiations going with North Korea? Do you see the human rights issue coming back to the fore, or do you think it is a much wiser path to push forward with sanctions and to focus on nuclear weapons? Or by leaving these things behind, you may never get them back, as far as you may, I suppose, send out a message to North Korea and to other nations that you can violate all the human rights you like, but as long as you have a nuclear weapon that we need to negotiate over, for example, then we will let you get away with it.
Yeah, that seems to be the crux of the matter. But I think the human rights issues, they will come back on the table. As I said, there are so many other third parties who have an interest in pushing forward to the improvement of human rights in North Korea. Does it harm the credibility of the R2P? I would assume yes, but once again, I think no easy answers. Does it send out signals to other countries? Probably yes, but I think the human rights issues will come back and to a greater extent in the near future.
So on that might be a good spot to leave the podcast on. So a lot of the research for this podcast that I did from my end has been from a number of articles that Boris has published. So I am going to link them at the bottom of the podcast, and I really encourage readers to go and listen to them. This is a topic that is really close to me. I'm fascinated by this. I'm intrigued by this topic, and I really encourage you to go and read a lot of these writings. And on that, Boris Kondoch, thanks for coming on the Korea Now podcast.
Thank you very much for your kind invitation and the excellent questions.